Okay.
Yeah, so hi, I'm Luke Blackadar. I'm the director of the Volunteer Lawyers for the Arts here in Massachusetts. Like Molly said, I met Molly about 2 years ago. We were talking with her and um, staff from other state arts councils about expanding our VLA services to serve the rest of New England. Um, but yes, I'm a practicing attorney. I mostly practice intellectual property contract, work with small businesses on business formation, nonprofit formation, really helping artists, creative entrepreneurs, and other small startups with just building their business, developing their practice, and really the way I often put it is what we do at Arts and Business Council is try and take some of the headache out of the administrative bullshit of being a professional artist. Because you guys conceivably want to actually focus on practicing your craft and creating art and honing your skills, not spending 5 hours in Microsoft Excel trying to manage your bookkeeping and stuff like that. So what we do at Arts and Business Council is really we try to unite the arts, the business, and the legal communities and try to create some synergy there. So I run all of our legal programming. We do lawyer referrals. We represent clients directly in-house. I do with the assistance of our executive director and also, a number of legal interns. We do in-house mostly kind of what I described, like copyright, trademark, nonprofit formation, for-profit formation, and other types of business transactions. But in terms of, our lawyer referral program, we help artists with really any legal issue that might affect them. Everything from, immigration, administrative proceedings to litigation, torts, injury, things like that. So don't be afraid to reach out. As Molly said, like we're working on creating a more formal relationship with RISCA and bringing our VLA services to Rhode Island, but there's a pandemic going on, everyone's in crisis mode, so we are currently opening our doors. Like if you have a legal issue, we do have an application process. Our website is at the end, and I'll put it in the chat at the end as well. You can take a look at that. Just, we do pro bono, we do fee referrals if you're looking to pay someone, so we're very flexible. So if you need help with really any type of legal matter, don't be afraid to ask. We are here for you, we're here to help. So just because we're not physically located in Rhode Island, like we still have a handful of Rhode Island licensed attorneys on our volunteer panel. So you're not without recourse. We'll do the best we can. So in addition to that, we do a lot of educational programming like this. We create a lot of educational resources. We created a whole library of COVID related resources, dealing with economic injury disaster loans, PPP, the other SBA relief programs, the eviction and foreclosure moratoria here in Massachusetts that have since lapsed, and really other things to think about in light of COVID. So, and we do normal programs like this as well, just about basics of intellectual property, basics of forming a business, basics of contracts, and a little bit of, starting to think about legacy planning and what you want to become of your body of work and your practice, and what legacy you want to leave and things like that. So we really, our programming runs the gamut, and we're happy to assist with really any legal issue or any, business of art issue that you have. So that's generally what we do at the VLA and the Arts and Business Council. This workshop is more specifically about intellectual property. So the bulk of it, we're going to talk about copyright. There's a little bit of trademark. I think this presentation also has a smidgen of contract in it as well, just basic contract principles. For the most part, we're going to talk about a little bit more of an in-depth introduction to what is a copyright, how do I use it, what are the rights that I get from it, what is the point, intro trademark, and I'll talk a little bit about licensing, even though that's kind of that's honestly could be a whole other presentation, but it's definitely helpful to know. So I defer to Molly's practice, but there's only 7 of us, so if you have questions, you can just unmute yourself. I do have 2 monitors, so I have you guys in the chat open on one screen, so if you do want to write your comments, that's totally fine too. But I have no ego about you guys just interrupting me. That's totally fine. So I like to start by putting all of this in context. We're going to talk about intellectual property in this talk, but I think it helps to kind of understand what intellectual property means kind of compared to other types of property rights. So there are generally three types of common or major property rights. Real property, which is a plot of land and permanent fixtures, a building, a house, etc. There is personal property, so that is tangible physical property that is not permanently affixed to a plot of land. So, your cell phone, your headphones, your laptop, your car even, things like that. As long as it is not permanently attached to a piece of land, that is personal property. And then this third category is intellectual property, and they're commonly referred to also as intangible property, and they're basically a property asset that isn't necessarily fixed to a physical piece of property, but still derives some type of economic value. And really, there are four buckets, but among that includes things like copyright, trademark, trade secrets, and also even things kind of a quasi-intellectual property right, but even like your right of publicity, the economic and commercial value of your name or your likeness. Those are different. It's not quite an intellectual property, but that's generally what we're talking about, and an intangible business asset. And a little piece of trivia is this, the image on the right, that is the actual patent that was issued by the US Patent and Trademark Office for the custom loafers from Michael Jackson's Smooth Criminal performance. So when he does like the 45-degree forward lean during the live performance, the shoes actually anchor into anchor points in the stage, allowing him and his dancers to do that like anti-gravity effect where they tilt forward. So we actually did apply for and obtain a patent from the USPTO for those shoes. So a little piece of, how the arts and, innovation as we kind of understand it in that like buzzword kind of way can combine and align. Also, we side note, we also run the official USPTO patent pro bono program of New England, and that we serve all of New England minus Connecticut. So if you're an inventor or you have, a design patent, or basically if you seek assistance with obtaining a either utility patent or design patent or other type of patent with the USPTO, then we can also refer you to a pro bono attorney for that as well. Just a side note, because we mostly don't get artists, but I've had a lot of musicians who have like musical instrument related inventions who come through our program as well. So it can happen. So within that last bucket, that intellectual property bucket, these are the four most common kind of the tentpole intellectual property assets. Copyright, which protects original works of authorship or original creative expression against unauthorized copying. Trademarks, which we think of as a brand protection tool, but it's ultimately a consumer protection tool. It is a device that ultimately allows us to identify the source of a product, the source of goods and services. So the example I always think of is, you go to DSW or Payless or, pick your shoe outlet, and you see rows upon rows of orange boxes. And without even seeing the name, the logo, or a description of what the product is, oh, those are Nike sneakers. That is the power of a trademark. It allows us to make quick decisions and quick identifications. And then from that, it's basically shorthand for our collective understanding of the value, the quality, the cost, and the all of those other considerations and the goodwill behind a brand or a product. So that's ultimately what a trademark is. That's the purpose of it. It's really, people use it to protect the consistency of their brands and their products, but it really is for the benefit of us, the consuming public, so we can make educated but ultimately quick purchasing decisions. And then patents generally protect useful inventions, useful novel inventions. So things like if you developed, a more convenient or an improved, bicycle chain or bicycle gear train or something like that, or I don't know, a better widget or something like that. That would be the purview of patent. Or if you discovered a new species of plant, or you created a new business method, those are the purview of patents. And then last, trade secrets are ultimately a secret that derives its economic value from, or a piece of information that derives its economic value from you keeping it a secret. So most commonly, that's going to be things like recipes. So restaurant recipes, it could even be formula for, cosmetics and hygiene products, body lotions and things like that. Those are really where you see them most often. They could also be things like customer lists or vendor lists or other types of business assets. The key of a trade secret is that you take some additional steps and usually incur some type of expense to keep it a secret. And that is really what gives it its power, because if it was disclosed to the public or other parties, then they could undercut your market. And I'm sorry, it is garbage day in my neighborhood, so there are people hauling dumpsters back, and it's loud on my end. I don't know if you can hear it. So why care about copyright? Why care about IP in general? Well, as you guys already know, your creative expression is valuable. Beyond just the value in the physical work of art that you create, for those of you who are, creating physical works of art like prints and paintings and sculptures and things like that, it has value. The intellectual property has value because it allows you to control the dissemination of your work. Who has access to it? Who can use it? Who can see it? Who can share it? And that has a lot of commercial power, because with that power to control the dissemination, you could have the power to control how it's going to be monetized and how it's going to be commercialized and who has the ability to profit off of it if in addition to you. And also, perhaps most importantly, knowledge is power and lawyers are expensive. Legal fees can range anywhere from $200 an hour at the low end to over $1,000 if you're working with a seasoned veteran at a big firm who's has 20 years of experience. So attorney time costs a lot of money. So having some of the common language and understanding the vocabulary of intellectual property can help you save so much time and ultimately make you a better client for an attorney if you do decide to work with them later on. So what is the subject matter of copyright? Ultimately, copyright, it protects original works of authorship fixed in a tangible medium expression. So there's three criteria there: original, a work of authorship, and this fixation. And I'll break down all three of those and what they mean. With respect to originality, the bar is very low. Really, technically, from a legal perspective, it just means that the work has not been copied. It's not a one-to-one copy of an existing work. You don't have to create something that's brand new and novel and has never been created before. It's just, as long as you have not completely lifted someone else's idea or someone else's expression. That's really all that's required. Obviously, you guys are all way more creative than that, and you're creating, things that are derivations and remixes and in addition to the things that you're just coming up with from your own imaginations. But for the legal standard, it has to has a modicum of creativity, which is an insulting standard to any artist, but it's the legal basis that we rely upon as attorneys. So the point of that is, a lawyer or a judge is usually never going to question whether or not your work is original. So what is a work of authorship? It's technically these 8 things, and they're very broad and they encompass a lot of different types of work. So literary works, that includes software. So if you're a programmer creating source code, object code, that includes that type of literature, that type of work. Musical works, including the words, lyrics, dramatic works, including the music, pantomimes and choreography, if you're a dancer, a performance artist, pictorial, graphic, and sculptural work. That's the bulk of the artists that we work with, those of you who are visual artists. Motion pictures, audiovisual, if you're a filmmaker, sound recordings for musicians, and architectural works for the design professionals out there. That's ultimately what these are. But even within these categories, they're all very broad and they cover a lot of different types of work. So what isn't a work of authorship? Usually they're going to be things that are really the purview of another type of intellectual property. So ideas, methods, and concepts, they're somewhat nebulous, first of all. So it's already hard to protect an idea with any type of intellectual property if it hasn't been expressed or committed to some type of tangible external perceptible form, but methods and concepts that also might be protectable by patent. Titles and short phrases usually are going to be protected by trademark. Typefaces also likely protectable by trademark, but the idea with a typeface is that it's utilitarian. It's the way that we communicate written language to each other, and we don't want someone to try and create a monopoly on the use of written language. That said, there's a weird distinction with fonts. If you're a typographer or a calligrapher and you're creating a new script that you bundle together and sell as a set, as a font set, that's doable. That is permissible, and that is technically copyright protectable. Candidly, I don't really understand what the distinction is. I know that it kind of falls within this utilitarian aspect of we don't want people to try and claim monopoly on a script, but I don't really know where the distinction ends. If it's just the bundling that makes a difference, I'm not sure, but just know that there's that carve out with respect to typefaces. Recipes, usually going to be formula, more likely patentable or protectable by trade secret. Scènes, faire, it's a French concept. It ultimately means that it is a element or an expression that is just necessary to whatever type of story or culture or scene that you're trying to communicate. I have an example on the next slide, but it's really just the French word for the thing that has to be done. If you're a filmographer or a cinematographer or a screenwriter and you're you like to do a Western or something like that, or you want to do a historical war drama or something like that, and you have an emotional scene between two soldiers in the trenches or something like that, no one can come after you and say, no, I have a scene with a tearful exchange between brothers in arms in the trenches. You can't do that. It's like, this is just part of the genre. Like, you don't have a monopoly on every single, on this hallmark of this type of expression. That's really what that means. It's kind of a nebulous concept, but that's ultimately what it is. There should be an ultimately counter somewhere in this video because I feel like I've already said it 10 times. Fashion designs, furniture designs goes back to that idea that we don't want people to try and claim monopoly on something that is useful, similar with typefaces. So clothing, fashion, it's ultimately to cover our bodies. It has a useful purpose. Furniture, it's meant to support us in our living situation, some type of functional use, storage or comfort or what have you. So with furniture and fashion designs, to the extent that there is a unique non-functional ornamental component to it, it might be protectable by patent, or it might even be protectable by copyright if you could physically and conceptually separate the ornamental element from the functional element. The most common example is if you create a sculpture that can be used as the base of a lamp or something like that. It's a three-dimensional sculpture. For example, if it was like Michelangelo's David, obviously well into public domain, but that sculpture itself could be separated and an individual three-dimensional work of art on its own without necessarily being a lamp base. So that's something that you could separate out and have that work of art be copyright protectable. But an example of something that would be difficult or not registrable is, think of those like really common, like undulating almost bicycle racks. Like, yes, it has somewhat of an ornamental, almost like a modern kind of a sculptural aesthetic to it, but ultimately it is also a very efficient way to store bicycles. So that you can't really separate the functional use from the ornamental use in that regard. So that's what we're talking about with furniture and fashion and clothing and these kind of works that straddle the line between functional and artistic and ornamental and decorative. And lastly, we have architectural works as depicted by photographs. Ideally, the work of the architectural work as constructed is functional. If it's not functional, you should be terrified and concerned. But a work of art, an architectural work as depicted in the drawings, the specifications, the design documents, that is a copyright protectable artistic expression. But as actually depicted by photographs, it's a functional building that isn't going to be protectable. Any questions on any of this so far? What a copyright is, what it means, what types of works are covered? Okay. So Scènes, faire, this is just an example. You know, if you want to communicate an old Cold War era spy movie or spy story, and you have a high stakes casino game, because that's what MI6 did back then. Another fun fact, apparently Casino Royale, like all of Ian Fleming's contemporaries were like, that's not fiction, that's literally what happened. Like, that was part of our operation during this conflict. Like, that scene actually happened. But if you wanted to tell that kind of story, the estate of Ian Fleming couldn't come after you and say, no, we have a high stakes baccarat game or what have you, with, you know, an antagonist and, you know, all these other players involved. It's like, you can't own the entire story. That's just part of the genre and part of that kind of historical genre of fiction. So that's really an illustration of Scènes, faire, but there are, you know, dozens upon hundreds of them. So the last element is fixation. We talked about what is originality, what is a work of authorship. Last element, fixation. What does it mean for a work to be fixed in a tangible medium of expression? It sounds complicated, but it's really straightforward. It just means the work has been committed to some type of tangible, reproducible form that can be perceived by other people. The point of this is that we don't want people to try and claim a monopoly, because copyright is, at its core, a monopoly. It gives you the exclusive right to control the dissemination and the monetization of a work. We don't want people to try and claim that on just an idea, just a nebulous concept or a concept in the abstract that hasn't been committed to some type of external form. So all this really means is that you have copyright protection once you have affixed your idea to, you know, paintbrush to canvas or pen to paper, or, you know, the film has been recorded, or in the recording studio, someone has pressed the record button on the sound recording software. Once those have been captured in a reproducible form, now copyright has taken effect. We call it the idea expression dichotomy. It just, again, means that we don't want people to try and claim a monopoly on an idea that they haven't actually expressed. Like, you can't tell a story about a fat orange cat who loves lasagna and hates Mondays. That was my idea. It's like, well, did you actually say it? No? Well, then tough luck. So that's really the idea of what fixation means. It has to be recorded, it has to be perceivable, and it has to be replicable. And as soon as you have fixed your work, as soon as you have created it and committed it to this tangible form, then copyright takes effect. You already have copyright and you already have some of the benefits that come with it. So this is just an illustration of different ways of, you know, a similar idea, or ultimately the same idea, you know, a kind of bumbling, well-meaning, but somewhat destructive parent figure, father figure, 6 different expressions of it. You know, Kevin James's cinematic career alone is like half of it. This is really the idea that you can have a similar idea, but very different ways of expressing it. And this is really the point of that fixation principle, is that if, you know, the first person to come up with, you know, the first one on this list could stop all of these other, you know, takes on this theme, you would lose all of these intellectual property assets. So what are the rights granted by copyright? And this is probably the most important slide of all of them. You get 6 exclusive rights, and they belong to the copyright owner, who is usually the creator of the work. And these rights belong to the creator and the creator alone. They are exclusive. The right to make reproductions of the work, the right to make copies. Copyright is the right to make copies. The right to make derivatives of the work, the right to take it and adapt it into other forms. It could be within the same medium. You know, you take one film and adapt it into another spin-off film. You take a painting and adapt it into another painting, or across medium. You know, Harry Potter started as a book, adapted into a film, adapted in the whole, you know, the entire pop culture empire that is the Harry Potter universe. The right to distribute reproductions of the work, either by sale, by gift, to give away copies of your work to the public. The right to publicly perform the work, the right to publicly display the work, and then the right to publicly perform sound recordings by digital audio transmission. Kind of a quirky new one that had to be added in virtue of, you know, things like internet broadcasting, internet radio, and things like that. But these are the ultimate, these are the 6 key rights that you get through copyright, and this is why this all matters. You have the right to control all of these elements of your copyright protectable expression. So who owns the copyright? like I said, by default, the person who creates the work, the author, is the owner of the copyright. There are a couple exceptions, and I'll talk about those. If it's a single author, the author owns the copyright 100%. If there are two or more, you are joint authors and you share copyright ownership equally. This third category, which is the exception to the rule, are works made for hire. And there are generally two categories within that, but most commonly that's where you're going to be an employee who is creating copyright protectable expressions within the scope of your employment. So that is everything from you are an animator at Pixar, you are a designer at an architecture firm, you created like this PowerPoint. This PowerPoint, I created it, I drafted it, but it is property of the Arts and Business Council because I created it on company time using company resources, and presenting it as part of my job description within my employment at Arts and Business Council. So really, it's pretty broad, but there are usually pretty common tells whether or not you're an employee. It gets a little bit more difficult when you're an independent contractor, but there's a lot of creative control by your employer. That's where things can get a little bit messy. But usually you will know when you're an employee, you're getting benefits, you're getting your regular salary, you're having taxes withheld, etc. Common hallmarks of, are you an employee or aren't you? So these are the two types of works made for hire, the one I just described, employees working within the scope of their employment. And then the second one is a little bit more specific and a little less common, and that is specially ordered or commissioned works. And I usually like to talk about this just because freelance artists usually understand commission as a certain thing. It usually means I'm a freelancer, I'm an independent contractor, I have been hired by someone, by a patron or a client to create a work of art, but I'm still an independent contractor. So you're saying a work made for hire, let me back up. Works made for hire, the employer or the person who hired you is the owner of the copyright. That is why it's an exception. When you're creating a work for your employer, the employer owns the copyright in that work. So now moving back forward, specially ordered commissioned works, just because you have, it doesn't mean the colloquial understanding of commission that we have. Like you have been sought by a client or a fan or a patron to create a portrait or design something or animate something, or you've even been engaged by RISCA for a public art contract. You're still treated as an independent contractor, you're not an employee. That is not the type of relationship we're talking about. With specially ordered or commissioned works, they really are just these 9 categories, and they have to be reflected in a written agreement as well, saying that you're giving the copyright to the person who has commissioned you. So for most artists, only a couple of these are going to apply. So things like contributions to collective works. So, for example, if you are a writer and you're a contributor to a literary magazine and you're contributing one piece, you're not necessarily going to own the entire work as a whole. Unless you have a written agreement, you'll probably own your individual contribution, your individual poem or short story or literary work. But if they had a contract with you that says, this is a specially ordered commissioned work, then the literary magazine that recruited you would own the rights in that work. Parts of a motion picture or other audiovisual works, so for you visual designers, and then I'm very loudly playing with a toy. So we have, if you're a cinematographer or a musician or a screenwriter, and you're contributing to a film or some other type of audiovisual work, again, if there is a contract that says that this is a special commission, then the producer or the publisher or whoever owns the rights in the film or the AV work would own your contribution as well. A lot of these other ones don't necessarily apply. Translations, maybe if you're a editor or a writer who translates other classic works or things like that. Supplementary works, instructional texts, tests and answer keys for tests, atlases for those cartographers out there. But for the most part, It's really going to be these first and second ones, and probably compilations that are usually going to be most relevant to you. And just know that, with the employment agreement, you'll generally know when you're an employee. And for especially ordered or commissioned works, you do have to sign an agreement saying that you are giving your copyright to the person who commissioned you. Does all of this make sense so far? That's probably one of the more complicated concepts, and I think it's downhill from here. So just know that ownership can be a little bit tricky when you do have complicated works that have a lot of distinct, independent, constituent copyright protectable pieces. Again, like I said, for film, that's usually, if you're participating with a film, you're usually going to have an agreement with the filmmaker, the producer, that you're going to have some type of work for hire or copyright assignment agreement saying you're giving me the copyright and your contribution to this work. But theatrical productions, you have the book, you have the manuscript, you have the songs, you have the actual recorded performance of the actors and actresses on stage performing the works of art. You have all these discrete protectable expressions. Similarly with video games, you have the visual assets, you have the score, you have the soundtrack, you have the actual source code for the program, for the actual functions. My dog is losing her mind. So transfer of ownership, and this kind of gets to copyright licensing and copyright assignment. But ultimately, the thing to know is that ownership of the intellectual property asset, ownership of copyright, is distinct from ownership of the physical personal property that embodies that work, that intellectual property, that copyright protectable expression. So quintessential example, you are a painter or you are a author. Just because you have sold copies of your book or prints of your painting or the physical painting itself doesn't mean that you've also given away your copyright. The copyright stays with you as the creator of the work. So that means you have the right to make reproductions of it. You can create derivatives, you can create prints of that painting. Maybe you've done a fine art piece, you've sold it for $5,000 to a collector or to a business that wants to display it in their lobby or what have you. You still retain the right to make copies and derivatives of that work and redistribute other copies of that. So you could sell prints of it. You could sell, you could share it on your portfolio available for download. That is within your right. You still own the copyright. Just because you have sold this physical piece does not mean that you have relinquished your copyright. Otherwise, you would own the rights to all of the books in your library, and that would be great, but not really productive for the authors. So just know that the sale of a physical work of art does not necessarily equal the sale of the intellectual property asset underlying that work. And again, with any type of permanent transfer of your copyright, unless you're an employee, and again, you'll know you're an employee, you can't inadvertently get rid of your copyright. You always have to transfer it, if it's a permanent transfer, by some type of written agreement that you have signed as the original copyright holder or the original author of the work. So you can't inadvertently give away your copyright. That said, there are a couple different types of copyright transfers. And the two most common ones I'd say are two types of copyright licenses and then copyright assignments. So copyright licenses are basically giving permission to a third party or someone else to exploit one or any combination of those 6 exclusive rights. So remember, the right to make copies, the right to make derivatives, the right to distribute copies to the public, the right to publicly perform, publicly display, public performance of sound recordings via digital audio transmission. So you have the right to give someone else permission to exploit one or any combination of those rights, subject to any terms or conditions that you want to impose or any other restrictions or limitations. So fairly common example is merchandising or selling copies. So let's say that you want to, again, to the fine art painter example, and you want to, you sold your main version of the piece, but you have, a high quality, high def picture of digital version of it, and you want to sell prints of it at your local either at a craft fair or, an art store or, some other location. That is your right. And what you'd have to do, or what you might do, is enter into a contract with a manufacturer or a printing company who is going to necessarily need permission to make and distribute copies. So you might have a license with the manufacturer who's going to physically make copies, and then another licensing agreement with the seller, the endstream or downstream seller who's actually going to sell copies of the work. They have the right to distribute copies to the public for sale. That's how licensing works. And you can, again, subject those licenses to whatever restrictions you want. So if you are an author and you contract with Penguin Publishing to publish your book, you can say, I only want to give Penguin Publishing a license to distribute my work within the continental United States. And then I'm going to go to Random House and I'm going to give them a license to publish it in Mexico, Canada, and the European Union. You can do that. You can set geographic restrictions. You can set temporal restrictions. You can say, I'm going to give you the license to publish my book for 5 years. And then after that, we'll renegotiate the license. Or I'm going to give the store a copyright term, a license term of 3 years to carry my products. And if they don't sell everything by the end of 3 years, we'll renegotiate the contract. Or if they do sell everything at the end of the contract, at the end of the license term, we'll renegotiate renewing it. That's another option. You can also limit the rights. You can say, kind of with the geographic example, but let's say that you are a composer. You're a musical composer. You create a musical composition and you say, okay, I'm going to give this person the right to publicly perform it. I'm going to give this person the right to remix it, adapt it, make a derivative of it. You can do that as well. So there's a lot of flexibility with copyright licensing. And then within that, the whole entire universe of copyright licensing, there are usually 2 flavors. Most commonly, you're going to see non-exclusive. And what that means is, in addition to your licensee, the person who you give permission to license your work, you also retain the right to exploit your copyright on your own. So I have given Penguin Publishing the right to publish my book in the continental United States. I also have the right to publish the book within the continental United States myself. I could do it through Amazon Kindle or whatever. You could also, the alternative to a non-exclusive license is an exclusive license. And I group it with copyright assignment because they're almost similar. Or they are similar, but they're not quite the same. So with an exclusive copyright license, that means your licensee is the exclusive rights user. They are the only people with permission to exploit your copyrights to the exclusion of yourself as well. So if you have an exclusive license, again, I've given an exclusive license now to Random House, who is they can publish my book in Canada, Mexico, and the European Union. I cannot self-publish in any of those locations. I've given them the exclusive right to publish my book there. That's what that means. So whenever you see a copyright agreement that says, or a licensing agreement that says exclusive, just be aware of what that means and always give it a second look and look at it very carefully and see exactly what you're relinquishing. Granted, an exclusive copyright license is temporary, and at the end of the license term, your rights do revert back to you. So make sure you understand what the term of the license is. If it is an indefinite term, what are the guardrails that you're going to put on it to make sure that you haven't ultimately kind of given away or assigned your work. And what are the restrictions on them and the restrictions on you. But those are the key differences between the 2 types of licenses. 1, I'm giving someone permission to use my work and I can still use my work myself. 2, I've given someone else permission to use my work, and for that period, I cannot exploit the work myself. The alternative to copyright licenses are copyright assignment. And this is transfer of ownership. This is, I'm giving you copyright ownership of my work. I no longer own the copyright in it anymore. You are the new permanent owner. You have the right to exploit those 6 exclusive rights. You are the exclusive rights holder. I no longer have any rights in this work. unless you've negotiated a license for yourself, which is also pretty typical. Usually where you see this a lot is music publishing, or more specifically with recording companies and recording agencies. You might be the composer of the song, but it's likely you might have assigned the right to actually create derivative works, or you've assigned the right in the sound recording to the recording agency that has actually recorded your performance of the work, or the artist's performance of the work. So, for example, the Beatles, I guess the estate of Michael Jackson owns the Beatles catalog, but Apple Publishing or Apple Music owns the actual rights and the sound recordings, the music as actually performed by the Beatles in studio. Music gets complicated. Music copyright is a whole separate 3-hour lecture, but that's a pretty common example of copyright assignments. I would also say, similarly with exclusive licenses, if you have an agreement that says assignment, I hereby assign my rights to company, commissioning body, whatever. Again, look at that very carefully and see exactly what you're giving away, and see if you're okay with that, and is the price commensurate? Is the fee that you're getting for assigning your copyright, for giving away and permanently relinquishing those rights, does the fee reflect the gravity of what you're giving away? For that reason, you'll usually see with copyright license agreements, the licensing fees or the royalties are usually going to be a lot less than what you'd see for a copyright assignment, depending on the work. But usually it will somehow reflect the nature and the permanence of what you are giving away to the other party. Any questions about copyright licenses, copyright assignment, or transferring copyright ownership generally? Okay, again, if you do, you can just unmute and you can leave it in the chat, or you can just shout it out. That's totally fine. So copyright duration, short answer is it lasts a really, really long time. So works created by individual authors, it is the life of the author plus 70 years, so virtually 2 lifetimes. For a work created by 2 or more individual authors, it is the life of the last surviving author plus 70 years. And then for works made for hire, again, works created within the scope of your employment, those specially ordered or commissioned works, or works that are made anonymously or pseudonymously. The term is the shorter of 95 years from publication. Publication is a technical term, or 125 years from when the work is created. So by publication, we mean when you've made the work available, you've made it available to the public for public dissemination. So usually for people to get it, either to get copies of the work for sale or for free or what have you. And I say this because it's a little bit complicated, and there's a little bit of confusion about it just because the nature of how easy it is to obtain things over the internet. But publication, if you're a visual artist or really any type of artist and you post your work on your portfolio, you share it within your portfolio or on your website, that's not the same necessarily as publication. Publication is, again, you're giving it to the public for them to take copies and make copies and enjoy copies of, again, either for sale or for free if you so desire. But really, if your intention is just to share your work in a way that demonstrates your skill, a sampling of what you're capable of in your professional practice, that's not the same as publishing. We're really talking about with publishing, most commonly, you're selling it to the public for them to enjoy. Where we understand a portfolio is more private, you want to share a sampling. That distinction is really ultimately up to your intent. Do you intend for people to take copies of this? And again, the reason I say it is just because if you have a website and you have your work there, it's very easy for someone to just right-click and download things. Unless you have some other type of technological safeguards, then it's fairly easy to get a copy of the work. So it really depends on, is your intention for people to download it freely and share it and use it? If not, then we don't have a publication problem. But that's what we're talking about with publication. Whole reason that copyright lasts so long is Sonny Bono from Sonny and Cher, US congressman, lobbied really hard on behalf of Disney to extend the copyright term for Steamboat Willie. So I think in the early 2000s, Steamboat Willie was finally going to enter public domain. Disney lost its mind and was like, no, we can't lose this. Lobbied the Congress really hard. Their champ, Sonny Bono, went to bat for them, and they got a 20-year copyright term extension. Very political issue. Both, the one side is we want more protections, more lasting protections for creators. View opposing is, but a rich public domain, a rich body of work for us to adapt, derive, remix from, allows us to have a more full, a richer creative economy. So there's arguments on both sides. Ultimately, in that regard, the side for longer protections for individual artists and creators won. But it's a political issue, but that's ultimately why. Steamboat Willie, I think, is going to go into public domain 2024, so we'll see. A lot of things happen in 2024, so we'll see what happens. Probably pretty far down on the list of interesting things going on that year. So when the copyright term expires, the work goes into public domain, and this is another term that has a technical definition. When a work hits the public domain, it can be used for any reason, by anyone, for any purpose, freely. Public domain means that the copyright in the work has expired. So I feel it's worth broaching that just because a work is publicly available or easily accessible or easily available does not necessarily mean it's public domain. And where I see this be a problem all the time is with, I feel oftentimes it's like stock photos and people grabbing stuff off the internet, people grabbing images off the internet for commercial use or use in their website and things like that. And just because you were able to download it, just because you were able to find it, just because Google image search turned up these results and they were easy for you to grab, does not necessarily mean that the work is in public domain. If you're able to find it on a resource like Google, it probably means there actually are still rights attached to it. So that's the key problem. So just know that public domain means that the copyright term in the work has expired. So that's really the key hallmark of that. Just because you're able to find it doesn't necessarily mean it's public domain. A lot of people have a misunderstanding of what public domain means. It's like, oh, I found this on Google, it's public domain. Or even worse, you find it on a stock photo website that's not really scrupulous or credible, and they say, oh, it's public domain, and it actually belongs to a photographer that didn't give them permission. Stuff like that happens pretty often. So just make sure if you are using source material for your work, if you're adapting it or incorporating it into your own body of work, just make sure you are very clear on where the source of the work is, that you either have permission to use it by license, or it is actually in the public domain, the copyright has expired and it's free for anyone to use. Other caveat is, just because the copyright protection has expired doesn't necessarily mean it might not be covered by other types of intellectual property protections. So it might still be protected by trademark, for example. Sherlock Holmes, starting in, I believe, 2018, very famously, the works started going into the public domain again. So now we're seeing the series of Sir Arthur Conan Doyle's books going into the public domain, and that raised a lot of concerns for the actual the legacy and the usability of the character. So just because the work itself has gone into public domain doesn't necessarily mean that perhaps the trademark right in the name Sherlock Holmes has not is available for use as well. It's a little bit complicated because copyrights and trademarks do protect distinct types of assets, but just know that there is some overlap sometimes. So copyright registration, now we have a little bit more practical considerations. Like I said at the top of this talk, once you have fixed your work in a tangible medium expression, you have copyright protection. You have those exclusive rights. They belong to you, and you have limited ability to enforce those rights. But a registration is recording your copyright ownership here in the US with the US Copyright Office, which is a section of the Library of Congress, or whatever the if it's a foreign copyright or foreign intellectual property authority, registering your copyright ownership, your copyright interest in that work with them. So really what it does is it creates a copy of a record of it in the Library of Congress, which is our national library, the biggest library in the country. It creates a record of your ownership. It creates a record of when the work was created, you know, when it was first published, etc. So the real advantage of registering your copyright is that it gives you the right, the ability, and it's a requirement for you to enforce your copyright in federal court. So if you actually wanted to sue someone for copyright infringement in federal court, you would have to get the copyright registered first. The price, is that per piece, a per piece cost? Kind of, it's per application. It's a little bit tricky. So there are a couple different types of copyright registration applications. So the simple one, it's like the easy application, is one work of art by one author, $35. What you do is you fill out an application, you either mail in or upload a depository copy of the work, usually the best representation of the work. So if it's a manuscript, you'd send them maybe a PDF of it or a Word doc. If it is a physical first publication of a book, you would send them a copy of the first publishing, etc. For works of visual art, it's a lot harder. If it's a physical piece of work, you might send a photograph of a sculpture, a photograph of a mural, a photograph of a painting. But that's kind of the easiest one. For all others, there's a standard application that's $55. And with the standard application, you can get up to 10 works if they haven't yet been published. So you can do a group registration of unpublished works. Again, they haven't been disseminated to the public. Copies haven't been disseminated to the public for consumption. You can bundle up to 10. They have to be the same type of work. So if it's literary work, it has to be up to 10 literary works. You can't combine it with a sound recording or a work of visual art. 10 illustrations. The only exception to this rule is if you're a photographer, you can bundle up to 750 photographs. What happened was there used to be no limit. So people were uploading and registering tens of thousands of works in one registration, and the Copyright Office had no way of vetting it. They had no way of examining it. That's not a very, there's a copyright examination process. Again, the bar for originality is very low. They're not the arbiters of what is art or what is, what is registered. I mean, they are the arbiters of what is registrable, but generally, if it's it meets that baseline of originality, they're probably going to register it unless they see an obvious problem. Like, if you're trying to register a copyright for the Mona Lisa, they're going to be like, I don't think so. I think the copyright expired in a couple centuries ago. So if you're submitting it for one work, then yes, it's $55 per work. It's $55 per application, but you can do that group registration of up to 10. So they impose the limitation to curtail kind of the rampant abuse of the copyright registration system. It's really easy to do. I usually, most people do it electronically now. I don't know if they have fully phased out paper registration. It's like $85 if you want to register it by paper. Oh, and now that I think about it, I forgot to update the slide. The prices just went up this year. They are now $45 for the easy application and $65 for the standard application. Still comparatively, it's inexpensive compared to applying for a patent or registering a trademark, but still budget it and work it into your practice budget if distributing works is a major part of your practice. So in addition to being able to register or being able to sue in federal court, it also gives you the advantage of, again, it creates a public record of your ownership. All copyright protected works, all copyright registered works are searchable, not necessarily the works itself, but you can look at the card catalog with the Library of Congress for works made after 1978. They're digitally recorded. You can, I believe, request a copy of the work. You can submit a written request. I don't remember how much it costs, but you can do that. Litigation attorneys do that all the time if you're suing for copyright infringement. So that's something you could do. So just knowing that registering your copyright with the Copyright Office does, in a sense, create a public record of your work. Doesn't constitute publication, but it does create a publicly searchable record of your ownership. It also creates a presumption of validity, and that is a legal concept. One of the things you have to prove in order to prove copyright infringement in court is that you own a valid copyright. And if you have a registration, we're going to treat that as a given. We're going to basically put the burden on the defendant, the infringer, to prove that you don't have a valid copyright. So that it basically eliminates one proof that you would have to demonstrate in court for copyright infringement. So that's one of the other key strategic advantages. My rule of thumb and my advice to artists and creatives is usually the more eyes that are going to be on your work, the more you should register it. So if you plan to widely disseminate it, if it's going to be shown in a gallery, if you're going to perform it, if you're going to license it, if you're going to market it, if you're going to sell derivatives of it, register the work. The more, it's just kind of a common sense argument. The more people are going to see it, the more opportunity there is for people to copy it and infringe it. So, you know, if it's your sketchbook or your journal where you keep, you know, your manuscripts or your drafts or your draft poetry that never sees the light of day, that never leaves your site, you probably don't have to worry about it unless you plan on selling that sometime later in your career. But if it is something that you're going to share pretty widely, if you're doing a public art piece, if you're doing a public art commission, you might want to register that, and you might even have in your contract, I don't know if this is RISCA's policy, but they might even say in the contract, like, duties on you to register the copyright in your work, and you really should. Like, you have the right to do it, and you really should if this is going to be a public work that we're going to be purchasing. So that's the advantage of registration. Again, you don't have to register in order to have copyright protection. You have it just by creating your work of art, but it does add some additional protections and advantages, and it really puts teeth to these 6 exclusive rights we were talking about. So the fun stuff, copyright infringement. What is copyright infringement? Anyone who violates any of those 6 exclusive rights, copies, derivatives, distribution, performance, display, performance of sound recordings via digital audio transmission, anyone who uses or exploits any of those rights without your permission, or a licensee who exceeds the scope of your license. Again, I've given Random House the right to publish my book in Mexico, Canada, and Europe, and they also do it in Kenya. Then that's exceeding the scope of their license. That is copyright infringement. They are copyright infringers. So how do you prove it? It's a little bit difficult. The easy piece is you own a valid copyright. Again, if you have a copyright registration, we'll treat that as a given. We'll put the burden on the other party to prove that you don't have a valid copyright. The harder piece is proof of actual copying. You're never going to get evidence, you know, eyewitness testimony of someone actually in the act of copying a work, because depending on what you're copying, it happens in a split second. So alternatively, we prove it by access and substantial similarity. Again, access is pretty easy. Were they able to see the work? Did they have access to the work? Was it available to them to copy? And then are the works substantially similar? That said, it is possible for identical works or even substantially similar works to be independently created that aren't infringing. And there actually is a fun local example of this in a couple slides. But how do we prove substantial similarity? Unfortunately, it is really hard to prove, or it's not necessarily hard to prove, it's just there isn't really a nice bright line answer. There isn't a nice black and white explanation of whether something is substantially similar. There are a couple different measures. I think currently the prevailing theory is this ordinary observer test, meaning if just an ordinary person like me was looking at these 2 works side by side, and I wasn't nitpicking, I wasn't looking at them with the intent of trying to divine what the distinctions are, would I think that the works are similar, or there might have been, you know, one inspired the other? That's one of the common standards, but ultimately just know that substantial similarity falls on a spectrum, and it's pretty squishy and subjective. On the one end, you have works that are so different that they are completely separate. They're so distinct from each other that there's really no way to tell that they're the same work. And at the other end, you have complete one-to-one copy. Substantial similarity is somewhere in between towards the copied end. But it's subjective, and really how it plays out in practice is a judge or a jury is going to be the deciding party if you go to court on it. So I think it's easiest to express it in examples. And these are a couple fairly famous copyright infringement cases. So this is Mannion versus VAT Cores. Photo on the left is Jonathan Mannion's photo from, I think it's Slam magazine. I don't know if it still exists, but a basketball magazine. That's a photo of Kevin Garnett. And the photo on the right is the billboard for Coors Light. And you can see pretty immediately that other than cropping out Kevin Garnett's face, this is an identical picture. It's just mirrored and it's black and white. So all they did was, take out the saturation, take out the coloration, and just mirror the picture of Kevin Garnett. Oh my God. So what happened was photographer sued, and the judge ultimately said, yes, these are substantially similar. Coors could have very easily just hired a model, dressed them up in similar, dressings, similar jewelry, similar, another white t-shirt, and that would have been fine. But here, you clearly just lifted the original photograph and just mirrored it, cropped out Kevin Garnett's face, which is the focal point of the picture, but it doesn't change the fact that you copied the exact photograph. So this was, yes, substantially similar. I don't think anyone would deny that it is. So here's another example. We have Gary Blem versus, I don't remember the name, but the creator of the Life is Good lifestyle brand, which, another piece of trivia, apparently our executive director, Jim Grace, was roommates with the creator of Life is Good. So college roommates. Like, however many degrees of separation from Life is Good brand. So think about that whenever you see those like tire covers on the Jeep Wrangler in front of you. So this was Gary Blem, who was the creator of Penmen, which is a serial comic, a newspaper comic, sued the creator of Life is Good, saying this is copyright infringement. I do these types of works. I create these stick figures, and I've done it for years. You're very much copying my work. So again, the court had to deal with the question of, well, are these substantially similar? And they said, yes, they are substantially similar, but as a matter of public policy, we don't want Gary Blem to own a monopoly on stick figures. This kind of gets to that idea, expression dichotomy we're talking about of, we don't want someone to have an exclusive monopoly on the idea of a stick figure. It's kind of the simplest, most reduced way of expressing human forms, and it's ubiquitous. We don't want this one person to be able to enforce his rights in this against everyone else in the world. So yes, they are substantially similar, but no, we don't think there's copyright infringement for public policy reasons. And this is my favorite example. So this is, a question of whether they're substantially similar. I think they are, but this is this was a case of access. So what happened was, this was early 90s, the New England Patriots were revamping their logo into what we now have. So the original Path to Patriot logo, now we're modernizing it. So somehow a graphic designer named James Grubb heard through the grapevine, I think he might have been friends with staff at the New England Patriots, that they are they're redesigning the logo. So James Grubb submitted a unsolicited design, the one on the left, to the Patriots. And on the right, you have the design from Evanson Design Group, which was the firm that the Patriots actually hired to design it. So naturally, this was the design they went with, and James Grubb was understandably very angry, and he sued the Patriots for copyright infringement. So what happened, by just almost sheer dumb luck, the Patriots were able to prove that, so they got their design, They got their design from James Grubb. They received it in the mail, I believe, on February 9th, 1993. They knew by timestamps and other, like, I don't even remember what it would have been. I think like just old time records and contemporaneous records from the time, that the design on the right was completed by their graphic designer on February 4th, literally 5 days before. And that threw the whole case out the window. That threw James Grubb's case out the window, because they were like, we had access to we had this one before we had access to yours. We didn't have access to your design at the time our artist completed this, so there was no way he could have copied it. So it illustrates access and also substantial similarity. I don't remember what the court decided on substantial similarity. I think they might not have even had to get to that question because there was no access. But that, just a fun little piece of New England history. So fair use. Fair use is a defense against a claim of copyright infringement. It is not an affirmative right. You might hear it kind of conceived as people try to kind of proactively say, well, it's fair use. You have to get sued first to be able to actually invoke this right or this defense. But the point of fair use is that there are certain public goods and public benefits that outweigh an individual creator's copyright and their creative expression. Criticism, comment, news reporting, research, scholarship, education, things like that. So what fair use means is, yes, I used your work, your copyright protectable creative expression without your permission. I am technically an infringer, but I am justified by this kind of, by the virtue of the nature of my use of the work. It serves a public good, so I should be excused from infringement, from being held liable. So there are two avenues to show that there's fair use and a work is fair use. The more traditional one is weighing these four factors. What is the purpose and the character of the use? Why are we using this work? Does it satisfy one of these purposes? You know, scholarship, research, education, criticism, comment, etc. What is the nature of the original copyright protected work? Is it truly a work of creative expression, or is it maybe a little bit more fact-based? The example I like to think of is if you are a fine art photographer versus a photojournalist who, your work, yes, it is creative, it is a work of creative expression, but the purpose that you're created the work for, or the nature of the work, is news reporting. You are factually reporting on what is happening, what is present here at this time in history, versus I am composing a unique work. It's my original imaginative creative expression, et cetera, et cetera. So what is the nature of the copyright protected work? How much of the work have you used? What is the amount that you've used, and how substantial is the amount that you've used? If you are sampling a song, are you sampling kind of a indistinct part of, you know, the backing instrumentals, or are you sampling the 3 seconds of the chorus out of the most important part of the song, the most iconic part of the song? And then what is the effect on the market for the original work? Are you actually usurping their market? Are you displacing their market? Are you diverting the consumers and the patrons and the customers of that original work to your own? Or is there no overlap? Alternatively to weighing these four factors, there's this transformative concept that you've taken a work, you've adapted it and really derived it and changed it so much, you've transformed the message and the purpose and the statement that the piece is creating, that we're going to treat it as a fair use because it's so different, it's so far from the original use and original nature of the work that, yeah, we're going to say that you're justified in this. Again, as with infringement, it's easiest to look at examples. First thing I'll say is parody and satire understand the difference. Satire is using a work of art to make fun of something else. Parody is using a work of art to make fun of the art itself, or using a protectable work to make fun of the work itself. So the reason this poster on the left is satirical is because you're not really making fun of the work, you're using it to make a comment and poke fun at the US government and, you know, kind of the overbearing surveillance nature of the US government. That's what this image is saying. Versus the one on the right is poking fun at that recruitment poster and also poking fun at Star Wars by combining the two and saying, look at this goofy recruitment poster. It'd be funny if we recast it in the Star Wars universe. You're using it to make fun of the original recruitment poster itself, and also, again, Admiral Akbar. So the point of this is parody is an acceptable fair use because you are commenting on the work. You need to be able to use the work itself to make a commentary or to criticize it. You don't necessarily need the work to criticize something else. And that is why satire is not usually, rarely ever, an acceptable fair use justification. So here's a pretty famous example. Jeff Koons and Art Rogers. So Art Rogers was a photographer. He took the photo on the left and he sold prints of it as postcards, I believe. And the one on the right is Jeff Koons' sculpture of the work that he created. So first of all, substantially similar. Yeah, I think they're, other than the fact that he added a few flowers, other than the fact that he changed the medium, from photograph to three-dimensional sculpture, he changed the size. The postcard, postcard's what, 4x6, and this sculpture is, I think, 6 feet by 8 feet tall. And yes, he changed the coloring. I don't know the color of the couple's shirts, but German Shepherds are definitely not blue. So yes, he's changed some things, but it's definitely substantially similar. So Art Rogers sued for copyright infringement, and Jeff Koons defended, saying, it is fair use. I am making a commentary on consumer nature, consumer culture of society. Doubt it. I don't know how that, first of all, it's more of a satire, not a parody. And second of all, the court was like, no, that's not. We don't believe that for a second. So Jeff Koons lost. Jeff Koons is for those who don't know, a very controversial artist, a very provocative artist. And the thing that was offensive, I don't know if it actually weighed into the decision in the court, but one of the things that was particularly offensive about this was Jeff Koons bought the postcard, tore off the copyright notice, and I think he just gave the postcard to his fabricator and said, hey, make this, and here are the colors I want you to do. How much is a postcard? Like 50 cents? He sold 3 of these sculptures, I think, to the tune of $300,000. So I think that was another thing that was particularly offensive to everyone who participated. Just like, Art Rogers maybe got a fraction of a cent in the royalties for the sale of that postcard, and Jeff Koons raked in, how many years' salaries from the sale of those sculptures. So he lost. Same guy, different dispute, different outcome. So this one is, again, we're dealing with Jeff Koons again. Here we have Andrea Blanche. She was a photographer. She submitted this piece to Allure magazine, or she's a advertising photographer, and this was her photograph for Allure magazine for Gucci sandals. So it's an advertising piece. It goes to that question of, what is the nature of the original work? Is it more creative? Is it more factual? This is a piece of advertising. It is a work of, commercial art. And then we have the painting on the right by Jeff Koons called Niagara. It's weird, and you can see that the second pair of legs from the left are these same sandals from the Gucci ad. But now he's added, a bunch of other legs to it. He's added all of these pastries. He's added a painting of Niagara Falls in the background. So Andrea Blanche sued, and again, Jeff Koons raised fair use as a defense. And here he won because the court said, yes, it's transformative. You've said something completely different with these works now. You have transformed the message. This is no longer an advertisement for luxury slippers. This is now, or sandals. This is now, this is now a creative expression. This is now communicating a new message. So you can see how, again, substantial similarity. He took an exact copy of that advertisement, but now he has cast it in a different context and he's created a new message with it. My favorite example is Shepard Fairey, the iconic Obama Hope poster. He took this photograph from, I believe, the Associated Press's photographer, Manny Garcia. This is then Senator Obama. He's at a meeting with, I don't know, he's at like a panel, like off camera is George Clooney, I think on like the right of him. So obviously it's been adapted into this now iconic Hope poster. Is it substantially similar? Maybe. It's definitely no question that this is the portrait that came from, or that you know, he took it from one of these images. But you know, now we have the rotoscoping, now we have the kind of the limited palette, we have the juxtaposition of the campaign logo and the Hope slogan. But this case was never decided. It settled out of court. I think most legal scholars would say, yes, this is a fair use because he's transformed the purpose of it's the purpose of the new use is ultimately to generate interest and hype and enthusiasm for the Obama campaign. And the original work is really, it's photojournalism. It is, hey, Senator Obama is at this event at this place and time. You know, how much of the work did you use? Well, you used, you know, cropped the image, but it is the focal point of the picture. It was Senator Obama. You know, does this displace the Associated Press's market for this use or for this photograph? No, the AP is going to be able to market this and shop this to other news outlets and all of the main news outlets without really having to worry about them going to Shepard Fairey and using his work instead. So it's a fair use, not really decided, but I think that's where the court would likely fall. And you'll notice in the case caption that Shepard Fairey sued the Associated Press. Why would he sue if he was the one who was potentially infringing? He sued for what's called declaratory judgment. Basically, he wanted the court to bless preemptively that this is indeed a fair use. I am clear. Please give me your blessing so that I can preempt the Associated Press from suing me. Obviously, the Associated Press countersued when they got wind of it, when they found out they were being sued. And then during the pendency of the lawsuit, Shepard Fairey deleted the original photograph that he used as a basis for his post. So he was criminally convicted for obstruction of justice and tampering with evidence pending a federal offense, a federal lawsuit. So if you take anything from this workshop, 6 exclusive rights, and if you ever get sued or sue, do not destroy the critical evidence that needs to be disclosed during the lawsuit. There's 2 things to take away from this message. So another fair use, another provocative artist, Richard Prince, who is a fairly well-known appropriation artist. So these are all photographs of taken from screenshots from Instagram posts by professional photographers. So this is their work. They shared it on their Instagrams. And what Richard Prince did was he took them, he added a comment. I don't know if he added a comment in Instagram or he photoshopped a comment onto it after the fact. But he took them, commented, blew them up to like, this is probably like, I don't know, like 6 by 4 feet, 6 by 10, or 6 by 8, I don't know. And he sold these to the tune of $10,000 to $100,000. So naturally, the photographers were very angry, and I believe they filed a class action lawsuit against him. And just adding insult to injury, he tweeted this, you know, phony fraud photographers keep mooching me. Why? I changed the game, and their wizardry, professional boredom keeps coughing up a Vicks Vapor Rub. I don't know what he's saying, but it was just like, you know, just rub that salt in the wound a little bit harder. I believe this also settled out of court, and I think these images, this is from, I want to say the Gagosian Gallery, I think. So just another example of, you know, an attempted fair use argument. I think it probably settled out of court, and I imagine he would have lost because he took virtually the entire photograph. That he credited them, that he credited their Instagram handles doesn't really matter. You'll notice that no element of copyright infringement. It's valid copyright and copying. It's not, you know, they also didn't credit me. Attribution doesn't really matter for purposes of copyright infringement. I think he would have lost because he changed the scale. Yes, he changed the medium, but the focal point and the ultimate image itself, the creative expression, is virtually unchanged. So, another example, and also an example of, again, how easy it is to infringe when you're posting your work in an online format. So at that point, we get to DMCA. Before I move on, does anyone have any questions about anything we've covered so far? I realize that it's a lot, and I've been going for an hour and a half straight. So if anyone has any questions or anything, feel free. Okay, so we'll move into digital then, and this is really quick. Digital Millennium Copyright Act, it basically appreciating that it's so easy to transmit files and work online, Congress had to adapt and amend the Copyright Act to deal with it. So the important things to know are these two provisions of the DMCA here. Anti-circumvention and notice and takedown, I'm sure you're familiar with, at least notice and takedown. So anti-circumvention basically means that if you have any type of copyright management mechanism, from something as elaborate to, including authorship information in the metadata of a digital file, all the way to something as simple as including a watermark, if you have any type of that copyright management mechanism on your work, it is a violation of copyright, a violation of the copyright statute to circumvent those, either by editing them, removing them, obliterating them, masking them otherwise, or otherwise altering them in some type of way. So that's the purpose of anti-circumvention. And what that means is, if you are sharing your works online, make sure that you're loading them up with data that shows your authorship. So go into the file properties and share and include that you were the author, when you created it, etc. If you have watermarks, use watermarks. Just consider the different ways you can kind of digitally protect your work. The things that on a very technical level you can do to put the world on notice that you are claiming copyrights. Even if it means including a copyright notice, like the one at the bottom of the slide, just the C in the circle, year of creation or publication, and your name. That is also copyright management information that is protectable. The alternative one, and probably more well known, is notice and takedown. And this is basically the internet service providers deal with Congress that, okay, in exchange for us not being personally held liable for copyright infringement that we facilitate by our end users, we are going to create a system for our aggrieved end users to issue a notice that there is infringing work on our platform and request for it to be taken down. So everyone's system is different. Every internet service provider has one, from the very high level, like your Verizons, your Comcast, etc., all the way down to your independent platforms like Facebook, Twitter, Instagram, Pinterest, and Flickr, all of those. So what this means is, if you see that there's work that is infringing your copyright protectable work, you see it on one of these platforms, they have to have a system for you to be able to put them on notice and transmit notice to the offender that you own the rights in this work and you have a right to request that it be taken down. Beyond that, every system has its own way of resolving it and deciding it. Some are very laissez-faire, some, like YouTube, are very strict and very militant and rely a lot on data to kind of do the grunt work and do the legwork for them. So that's the point. My advice with respect to this is, whichever platforms you are using to share your art, whichever third-party internet service providers and platforms you're using to distribute your work, get familiar and understand where to find their DMCA notice and takedown mechanisms, and start to familiarize yourself with how to use them. Depending on the nature of your practice, you might find yourself having to do them a lot, or do them a little, or really just use them to kind of nudge people into, you know, credit me or, you know, ask my permission first or otherwise try and just mitigate a situation. But I usually recommend wherever you're sharing your work, understand what their DMCA notice and takedown procedure is. It's going to save you a lot of time and a lot of headache later on when you do find yourself in a situation like, oh, I have to do this and I don't know what to do. It's usually going to be buried somewhere either in their policies, terms, or legal. Usually it'll be under legal, and then you'll see intellectual property or copyright, and then they'll say what we do to protect our users and your content, things like that. You'll find it. They're all generally kind of the same defined, but again, every system is different and every platform has a different way of managing and like arbitrating these disputes. So moral rights, I'll talk about this really quickly. Moral rights is a section of copyright. It is an extension of copyright, and it protects the physical integrity of a work, and by extension, your professional reputation. So on the federal level, we have the Visual Artists' Rights Act. It only applies to works of visual arts. And what it does is allows certain works of visual art that are, you know, limited copies and of a certain stature. It allows you to prevent people from making alterations to the work that would change it from your original expression. So if you had a sculpture and someone bought it and then they beheaded it, then you would have the right to, one, prevent them from doing that, or seek damages for, seek money compensation for the damage they've done to the work. And also another powerful tool is it gives you the right to disclaim your association with the work. So, you know, I had a professor of sculpture who said, I tossed out a ton of sculptures like 30 years ago. I thought I got rid of them. They wound up in dumpster. Someone took them, and they've like deteriorated over time. They've degraded, and they've also like painted over it. It no longer reflects my work, but it still has my artist stamp on the bottom of it. What rights do I have? Well, you know, if you're an artist of a certain stature, and this professor had a very strong reputation, you have the right to disclaim attribution, or you have the right to withhold and withdraw your attribution to it. Like you can say, no, this isn't my work anymore. And if you're a high enough caliber artist, that is a very powerful tool. But it honestly is a double-edged sword. Like if you're a certain caliber, then that can either tank the cost, or if you're a high enough caliber that people kind of want like contraband version of your work, then it might drive up the cost. So it is kind of a double-edged sword. For many artists, you might not encounter this issue. Again, it is for works of visual art and limited, usually limited signed versions of it. Massachusetts has the Massachusetts Arts Protection Act, and the statute in Rhode Island is virtually the same. I don't think there is any major distinction between the Rhode Island equivalent. This one is a little bit more specific. This one is for work of recognized quality, and it does have to be a work of fine art. And usually that means if you want to prove that you have someone has infringed your moral rights, you have to hire an expert, usually a curator or someone else in the field who can opine on it. But similar relief, damages, injunction, basically in order to have someone stop doing something, and also attorney's fees. So that's really quick moral rights. Couple exceptions: changes and modifications due to passage of time, you know, degradation of the materials, modifications that happen in virtue of conservation efforts, unfinished or abandoned works, things like that. Those are exceptions to the rule. So really, usually logical. Like I can't control, and people can't control the weathering of materials. So it just happens. You can't sue me because I did my best to try and conserve it, and it happened. So anything on copyright before we immediately jump into trademarks? Okay. So like I said, a trademark is a source identifier. It's a consumer protection tool. And there are, you know, a trademark could be a word, a symbol, a phrase, a slogan. Or it can be something a little bit non-traditional. It can be a scent or a sound or a color. Whenever you walk by an Abercrombie and Fitch and you feel yourself gag, like you're smelling a trademark. So the idea, again, is the trademark identifies the source of a product. Service mark, it's the same as a trademark. It just, trademark identifies goods and products, and a service mark identifies services. They're the same. You use TM for everything. It's fine. So trademark rights arise from actually using the trademark in commerce, meaning you are actually using a trademark on a product or service that you're actually offering to the public in the marketplace in a very external, public-facing fashion. So you can have one trademark and multiple different types of expressions of that trademark. So you could have, in the center, we have what's called standard character trademark. That's just protection for the word Nike and really any appearance. You have the orange boxes that I mentioned. Color by itself is not inherently functional as a trademark, but if it is associated after a long time with certain goods and services, and you've kind of developed a reputation and you've built up this consumer secondary meaning, then a color can serve as a trademark. So think of your Tiffany blue, think of orange and pink for Dunkin', think of, you know, what is your favorite sports team? What's your favorite, you know, university, your college colors, things like that. Like after a certain amount of time and a lot of public exposure and public education and marketing and branding, a color or a non-traditional mark can eventually serve as a trademark. You have the Air Jordan silhouette, you have the swoosh plus the words Nike. There are all different types of trademarks, and they can be used in all different types of combinations. Again, when you think of, you know, high-end, again, cosmetics and perfumes and food and things like that, those can also be trademarks because they identify without you really even necessarily processing what the name of the product is or you know exactly what the product is. You know exactly what it represents. That's what a trademark does. So we evaluate a trademark based on how strong it is. The strongest trademarks are the ones that are either arbitrary, you're using an existing word in a completely random way that has no association with the nature of the word. Iconic example was Apple. Has nothing to do with the produce, has everything to do with, you know, computer, hardware, software, music, things like that. Or fanciful, totally made up word. Rolex, Hans Wilsdorf, like he was just like, I want to create a luxury watch brand. I need a name that kind of sounds luxurious. Rolex sounds kind of cool, and Rolex was born. Nothing to it other than this random Austrian guy thought that it sounded like a fancy word, so this is what we're going to do. And you know, second are suggestive. Suggestive marks are also fairly strong trademarks. They're trademarks that identify a quality of the product, but take kind of a leap in logic, kind of a jump to make the connection. So example is Jaguar. Very fast, sporty motor vehicles. Jaguars are very fast, athletic animals. Okay, there's the connection. It's not immediate, but it is there when you think about it. So suggestive marks, arbitrary marks, fanciful marks, just by their virtue, are protectable as trademarks. Then you have descriptive marks. Descriptive marks are exactly as they sound. They describe a quality, characteristic, ingredient, function, etc., of the actual product or service itself. So domestic airline carrier, American Airlines. Is it an American airline? Yes, it is a descriptive mark. So a descriptive mark, it's not inherently, it doesn't inherently serve as a trademark, but after many, many years of use and developing that goodwill with your customers and putting yourself out there over time, now it is a registrable, protectable, enforceable trademark, because now we all understand what American Airlines means. And then at the very end, you have purely generic. It doesn't describe the product, it just is the product. So my favorite example, my wife and I would always laugh when we went to Price Chopper when we were in college and we saw crispy hexagons, because it was like, how much more blatant of a generic could you get? Like, nothing creative about it, nothing inventive about it. It's just, these are crispy rice hexagons. It's hilarious. So generic marks are never registrable. They never can serve as a trademark, because when I see a box that says crispy hexagons, I don't really know. This just tells me what it is. It doesn't tell me anything about the original creator, the manufacturer, the producer. I don't know. I can't make a decision versus like checks. Okay, I know what that means. So here's just kind of a visual representation of the relationship between strength of a trademark and how distinctive the mark is. You see that the more distinctive the trademark is from the products that are associated with it, the stronger the mark is, and that's the idea. So to make things even more confusing, sometimes you do have works of fine art, works of visual art, works of creative art that incorporate trademarks. You might see this in a very uncommon example, like things like visual fine art. More commonly, you might see it in photography. You might have a concern, I've had a number of photographers come up to me and say, I want to take a photo shoot and it's out of this, this landmark. Can I do that? Can I legally do that? Or am I going to get sued for trademark infringement? Like, I want to take a photo shoot in front of the New Balance factory in Brighton, Massachusetts, or what have you. Can I do that, or is that trademark infringement? Well, no one's going to assume, for the most part, that you are trying to usurp the trademark holder's market. Like, think of the iconic like Andy Warhol painting of the Campbell soup can. Is anyone going to think that Andy Warhol is trying to get into the business of condensed soup? No, it's a work of fine art. It's his own unique creative expression. I don't think Campbell's would ever get the impression that he's trying to impinge on their market. But there might be a situation where someone might think that your work has been sponsored by the trademark owner or the brand owner. So it can get a little bit squishy and a little bit confusing. Again, think of the way you're using, if your work does incorporate trademarks, recognizable trademarks, think of how you're using it. If you're using it in a fine art example like this, you're probably fine. If you're using it for like, if it's in the background of photography, you're probably fine. Now, if you're using it, in a way that advertises another product, like your work of art is used to, for example, if you're like you're a marketing photographer and you sell images for the purpose of like to be used in advertising and things like that, then it might be a problem. Then someone might think, oh, well, this product is sponsored by this other brand. So that might be a problem. But the hallmark of trademark is trademarks have to be used in connection with a product or service. And for most artists, you're not using a trademark to sell another product. So like, you're not using this trademark to sell Starbucks coffee, or you're not using this painting to do that. So you're probably fine depending on where you are. So that is IP. I have a little bit on contracts. I don't know if Molly, if you want me to do contracts, or I'm fine. We have 15 minutes left. I'm fine doing, if you guys want to ask questions or things like that, that's okay with me.
I think I'm talking about contracts next week a little. Okay. I'm always happy to have an actual expert rather than me talk about it. But I think like if y'all have questions, now might be the time.
Yeah.
How y'all feeling? Was this helpful? Okay.
No, it was helpful. I think it's a lot of information.
Yeah. No, it is a lot. And honestly, like, I studied copyright for a whole semester in law school. Like, all of these things we talked about are entire legal disciplines in and of themselves. It's hard to condense it into 2 hours. It is a lot. Try to touch the high points and try to have it reflect a lot of the questions that I get most commonly. It's usually, because I usually get it from kind of two perspectives: of the perspective of one, I want to protect my work against other people, or two, I am an appropriation artist. I rely upon a body of existing work to create my work. how do I avoid myself getting in trouble and infringing someone else's work? How do I do it best? So it's, you kind of got to think of it, it's the same real analysis for both sides. It's identify the source of what you're getting your materials from, assessing what are the rights in the materials that you're using, and similarly, how much are you putting your work out there, how much access do people have to your work when you're distributing it and sharing it, and what measures are you taking yourself to make sure that you are making your copyrights and your trademarks, if you're working on them, enforceable. I would say one thing about trademarks is usually in the context that I see this most often is either a collaboration agreement between artists, musicians often. There might be some kind of term about, using, what permissions do I have to use trademarks? Licensing with trademarks is very similar to licensing with copyright. I have the permission to use this trademark for certain limited purposes. But the other thing is, when you are alternatively is if you're an artist, a visual artist, a designer who is designing trademarks for other people, for other companies. And what happens is, and what makes it confusing is a trademark like, let's do the Jaguar logo. That is an original work of creative expression. That is original work of two-dimensional artwork. That is a copyright protectable expression. So now you have one visual asset with now 3 potentially discrete property interests. You have the IP in the copyright, the IP in the trademark, and the personal property if you were selling prints of this. So where it gets confusing is if you're a designer, by default, you might be the owner of the copyright because I'm a freelance graphic designer. I designed this for Jaguar Motors, and I own the copyright in it, but they own the trademark because trademark belongs to the person who's using it. It doesn't matter who created the trademark. It matters who is using the trademark to sell a product or service. So what you'll see pretty often if you fall into that category of professional graphic designer, and you do logo designs, you might see in your contract that in addition to disclaiming any rights in the trademark, you will also be assigning your rights in the copyright to the company because they want to own 100% of all of the intellectual property assets associated with the work. So, and in those cases, it makes sense. I've had some graphic designers who are a little bit hesitant and like, I don't want to give away the copyright. It's like, what are you going to do? Do you think that they're going to let you sell prints of their logo? Absolutely not. They're not. They'll come after you for copyright infringement faster than you can say, oh shit. So it's not uncommon for when you've been commissioned to create a logo or a brand design, that your client will ask you or demand an assignment of the copyright in that work as well, because they want to be able to exploit 100% of it. They want full creative control over the dissemination of that work. So that's the one weird caveat and the one weird situation where copyright and trademark aligns and overlaps. But other than that, it'll be fairly simple, and you'll know what you're doing. You'll know when you've been asked and what permissions you have. Most people are going to be fairly forthcoming about what I'm giving you the rights to use and what I'm not giving you the rights to use.
I think when I was learning about, and instead of going to law school, I took 1 semester of arts law in grad school from an arts lawyer. One of the things that struck me the most was the pursuit of profit and the profit motive, and how strongly that plays into particularly the case law in both trademark and copyright. So like, it's terrible, y'all, but you always have to be able to, like, for everything. I mean, we talked about taxes and avoiding hobby loss. You always have to be showing that, like, your goal is to make money.
Yeah.
Which is rough.
Yeah, and that is the biggest in tax and with the hobby loss rule and stuff like that, because it is tough being an artist. It is tough. It's tough for a number of reasons to be a professional working artist, but it's also tough because culturally and institutionally we have this idea that, oh, it's a hobby. oh, that's so great, you're doing this like fun thing. That's a nice little hobby, but like, what is the real work you do? Come on. It's like, no, this is my real work. And you have to go out of your way to justify to, various government agencies and institutions that, no, this is my livelihood. I'm doing this to put a roof over my head. This is how my chief source of income, or one of my major sources of income. Yeah. So, and you see it does bleed into these other areas of like, fair use is like, are you hurting this other person's profit motive for their work? Or for trademark infringement, are you interrupting their interaction with their consumers? Are you confusing and diverting consumers away from their products to yours? Are their buyers mistakenly attributing your services to them, or vice versa? So a lot of these things, and for really any type of claim you ever make in court or any type of lawsuit you file, usually there is going to be some type of proof of, I suffered an economic harm as well, resulting in some type of economic injury. So it does a lot of times boil down to dollars and cents. So all of this is just more reason to think critically about running your art practice as a business and thinking of it as the business of being an artist. And it's hard. It's hard even, prior to coming to Arts and Business Council, I was a solo attorney and I started my own law practice. And the business, they don't teach you the business of being a lawyer in law school either. I was projecting earlier. I didn't want to spend 5 hours a day in Excel spreadsheets, but that's what I had to do. It's hard because you spend so much of your time and your training learning your craft and learning how to solve this problem. For me, a legal problem; for you, a design problem, an illustration problem, a musical problem. You're taught to solve these problems and not really taught how to sustain yourself once you get out there. So it is kind of like backtracking, unless, those of you who might have business backgrounds before going into art, then you might be a little bit in a different position. But yeah, it is kind of learning a new skill set.
Cool. So usually I wrap up by telling y'all what's coming up this week. There's nothing coming up for Riska this week. Where pretty much everybody is out of the office Wednesday, Thursday, Friday. Next week on Thursday, we have a artist peer support call. Hi, Kat. An artist peer support call that's being led by Anthony Andrade and Matt Garza about mental health for artists. They're both certified yoga practitioners and do a lot of work in this area, as well as being just really excellent artists and teachers. And then, yeah, all the commerce stuff is still happening. If you need help, let me know. That's all.
Thank you. And thank you, Luke, for your time and a lot of information that was really, really helpful. So thank you so much. We appreciate it.
Yeah, happy to help.
Okay. Have a lovely holiday weekend with your household units, y'all. I don't know what those, hi, Kat. I don't know what the regulations are in Massachusetts, but here we're limited to social gatherings within our household. So my partner and I are planning to get sushi on Friday for Thanksgiving.
Nice. Yeah, I'm sure we have guidelines. It's like my wife's parents live in New Hampshire. My mom lives in Florida, so I'm not going anywhere. We're having seafood fettuccine Alfredo. That's what we're doing.
Nice.
Yeah.